I beg to appear in this matter.
Yes, Mr. Sondhi, how much time you will take?
I will take about half an hour at the most, my lords, for my rejoinder.
Your homeopathy undertaking is still there?
It stands, my lords.
Yes.
Unlike the state, my lords, I cannot renege.
Pardon?
Unlike the state, my lords, I cannot renege from directions of this honorable court.
Please continue.
Please, my lords, I'm
Mr.
grateful.
Sondhi, just remind us about your WP number.
Yes, my lords. 23775 of 2024, my lords.
Yes.
Item 90, though your lordships are using the papers in 89.
Yes.
Grateful. My lords, one of the key responses that my learned friends for the respondents, my lords, have made is the reliance on the judgment of the Supreme Court in Ashok Kumar's case.
Yes.
To argue, my lords, that by having participated, written the examination, we are now estopped from raising this challenge. Now, my lord, in Ashok Kumar, the Honorable Supreme Court has in fact, at para 15, relied on an earlier judgment of the Supreme Court in Manish Kumar Shahi's case.
Yes.
And laid down a principle. Now, this judgment, my lords, has been duly considered at least twice by the Honorable Supreme Court subsequently. One, of course, my lords, is the oft-cited judgment in Major Meeta Sahai, where at para 15 onwards, if your lordships permit me to read.
Kindly give the citation. Is it part of your compilation?
Yes, my lords. Page 313 of the judgment compilation. 2019, 20 SCC, page 17.
Yes.
Kindly come to para 15, lords. At 321.
Yes.
Preliminary issue. Furthermore, before beginning analysis of the legal issues involved, it is necessary to first address the preliminary issue. The maintainability of the very challenge by the appellant has been questioned on the ground that she, having partaken in the selection process, cannot later challenge it due to mere failure in selection. The counsel for respondents relied upon a catena of decisions of this court to substantiate his objection. It is well settled that the principle of estoppel prevents a candidate from challenging the selection process after having failed in it, as iterated by this court in a plethora of judgments, including Manish Kumar Shahi, my lords, which is relied in Ashok Kumar, observing as follows. Then, my lords, para 16 of Shahi is extracted. Now, my lords, please come over the page. The underlying objective of this principle is to prevent candidates from trying another shot at consideration and to avoid an impasse wherein every disgruntled candidate, having failed the selection, challenges it in the hope of getting a second chance. However, kindly mark para 17. We must differentiate this principle insofar as the candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules, as is the case here, and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and impermissible. In fact, notes, kindly also mark this, a candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless he or she participates in the selection process. So, my lords, participating is not accepting the illegality. The principle that my friends are arguing is more, my lords, for example, if there is bias alleged, against a particular examiner, and one is aware of that disqualification, chooses to appear before that examiner, then he or she may be stopped. But when it comes, my lords, to a question of illegality in, my lords, the manner in which the process has been conducted, then, my lords, locus in fact follows only when a candidate, my lords, participates and he or she is not stopped. And this judgment, my lords, as I submitted, considers Shahi, which was referred in Ashok Kumar's case. And incidentally, my lords, after Major Mita Sahai, the Honorable Supreme Court has quite recently, in a judgment in Abhimeet Sinha, page 327 of your lordship's compilation, had a recent occasion, my lords, to once over consider this question. This is 2024 7 SCC 262. Please come to para 35, my lords, at 347. Maintainability.
Yes. Maintainability.
Yes, my lords, maintainability. At the outset, it is apposite to address the issue of maintainability of the writ petition. It is argued by Mr. So-and-so, learned counsel, that having participated in the recruitment process, the writ petitioners, having not succeeded, cannot turn around and challenge the recruitment process or the virus of the rules. It is submitted that all candidates knew about the prescription of minimum marks for viva voce well before the selection process commenced, and the principle of estoppel will operate against the unsuccessful challengers. On the other hand, the learned counsel representing the writ petitioners argued that the principle of estoppel will have no application when there are glaring illegalities in the selection process. Further, estoppel is not applicable when arbitrariness affects fundamental rights under Article 14 and 16 of the Constitution of India. As argued by the learned counsel for the High Courts, the legal position is that after participating in the recruitment process, the unsuccessful candidates cannot turn around and challenge the process. However, it is also settled that the principle of estoppel cannot override the law. Such legal principle was reiterated by the Supreme Court in Mita Sahai, wherein it was observed as under para 17, which your lordships have presently seen. Guided by the above ratio, in matters like this, to non-suit the writ petitioners at the threshold would be hardly reasonable, particularly when the alleged deficiencies in the process could be gauged only by participation in the selection process. And, my lords, this principle at para 35, that, my lords, law trumps estoppel, is too well settled. The Article 14 element, if my lords kindly recall my earlier submissions, I had sought to respectfully contend that there is, in fact, my lords, patent arbitrariness in this case. And that was because of the threefold violation on their part in, my lords, disregarding the orders of this Honorable Court, in wrongly bringing in Badawat's case, and the manner in which the reservation process 1:50 allocation, etc., was violated. That is manifest from the record. Now, my lords, in this regard, my learned friends have, maybe advisedly, not touched upon the submissions on our side that this particular action of theirs is in, on the face of it, is in violation of the directions passed earlier, my lords, by the learned single judge and confirmed by the division bench. The directions are in rem. Once those directions are in rem, to bring in a principle of estoppel, my lords, to try and non-suit a writ petitioner would not lie. And the only justification that has been sought to be provided is, my lords, the fact that the web note issued by the PSC cancelling the earlier recruitment was subject matter of challenge in another writ petition. My lords, first and foremost, those two proceedings did not decide the correctness of the decision. That would be very important. the order of the learned single judge dismissing, my lords, that collateral petition was on the ground of laches. There was a contention there as regards 14 questions being erroneous. There was also a challenge, my lords, to the re-notification at page 27 of the judgment provided by my learned friends for the respondents, my lords, in WP 21239 of 24, where the web note of 19/2/24, my lords, was impugned. Please see page 27. I hope that is before your lordships.
Justice
My lords may just mark the page, my lords. I will give your lordships a written note.
Yes.
Please, my lords, just kindly mark page 27 of that order.
Yes.
Which holds, if the petitioners are really aggrieved by the cancellation of notification 4 of 22, dated 26/4/22 through web note dated 19/2/24, they ought to have approached this court and challenged the same at the earliest point of time. Though the delay on the part of the petitioners appears to be only 6 months, but in a matter of this nature, the day-to-day delay matters, and further the petitioners failed to explain even a single reason for the delay in approaching this court. Therefore, on this ground alone, this court is not inclined to entertain WP so-and-so without adverting to the other grounds raised therein. So, my lords, a dismissal on laches is not a certificate to the PSC to violate a direction of this honorable court. My lords, I grant that we have not challenged this cancellation, but the conduct, and your lordships, as I submitted, my lords, in 226 read with 215, the conduct of the respondent in disregarding a direction of this clear direction. Lordships will recall one cancellation because of some...
You already argued reconduct. The argument is based on the direction of reconduct.
Reconduct.
Yes.
And that, my lords, that there is not an iota of material to make good why the orders of this honorable court were not adhered to. Neither in the web note is there a reference, and nor, my lords, in this order that my friends place heavy reliance, is there any adjudication or determination made. And that goes to the root of the matter.
Yes.
That, my lords, is in rem. Now, my lords, as regards the process itself that the respondents have deployed, my lords had put me a pointed question as to how this current process would be prejudicial. And I think I was not able to suitably articulate it earlier, my lords. Please permit me to clarify. With the present methodology that the respondents have used, they are basically, my lords, on a misreading of Badawat's case, going by 563 into 50. What they should have done is gone by 209 into 50 for the general merit and respectively for the various other categories. Now, why, my lords, this 563 into 50 could be prejudicial or adverse to our rights is that when you take 563 into 50, there are far more number of candidates, my lords, who would apply. As a result, there is a far greater chance, and I have prepared an illustration which I will place. There is a far greater chance that non-BC candidates having higher marks will fill these 209 posts. As a result, my lords, the meritorious BC candidates will be confined to the BC list, thereby reducing the chance of other BC candidates, my lords, to be recruited in the process. Whereas, if it was done at 209 into 50, a high ranking or a BC candidate with high marks would have a far greater chance to be absorbed, my lords, in the general category. And this is not, my lords, rocket science for the state. This is, in fact, your lordship's view. What my lords laid down in Kishore Chaudhary, approved by the Honorable Supreme Court in Dipender Yadav, is the law. That it has to be done, my lords, category-wise.
That was precisely Mr. Madan Mohan raised, that it should be compartment-wise. category multiplied by 50.
Yes, my lords.
Yes, yes. That has been reiterated. Yes.
I'm grateful, my lords. I'm only hoping, my lords, that this illustration would in fact make it clear. It's not just technically that we are arguing it should be category wise. The effect has to be same. That a BC candidate, supposing a BC candidate
Yes.
who meets slightly lower than the cutoff in the or is close to the cutoff of the GM, he may be the highest ranking, my lords, in the BC category. But because there are far more numbers, that is 563 into 50, who are contesting, the higher ranking non-BC candidates will edge him out. He will get pushed into BC, and all other lower ranking BC candidates by default will be excluded from the process. It is exactly to avoid that my Lord Justice Paul's judgment, my lords, in fact, in Kishore Chaudhary has very eloquently dealt with it, which I had read to your lordships again, my lords. It is in my lord's compilation at page 390, para 33. Lordships have already marked that when I had argued, my lords. I'll page. I'll just tell your lordships.
That is the page number
35, my lords, of the judgment compilation. Yes, yes. Where my lords at para 33 had looked at the constitutionality of Rule 4.3d.
Yes.
Refer to the law in Indira Sani at para 34, my lords.
Yes.
That reserved candidates have the right to be treated as open competition candidates. And followed, my lord, Saurav Yadav.
In fact, Mr. Sanghi, all this has been argued in great length in the
Very
first
well.
round. What we expect that in rejoinder you will deal with those bullet salient features which have come for the first time for the by the others.
I'm fully conscious, my lords. I'll stop here by saying that your lordship's view in Kishore Chaudhary has been, my lords, affirmed in Dipinder Yadav's case.
Yes.
Which in turn refers, my lords, to refers to Saurav Yadav's case. And there, I won't, my lords, read those paras again, except to say that at para 30, para 30 to 32 of Dipinder Yadav,
Yes.
the position is very clear, my lords, that the adjustment shall be only at the time of final selection. So in other words, my lords, separate merit lists are to be prepared. It cannot be done en masse as the state has sought. And if your lordships see the web note, the position becomes even more, my lords, arbitrary. There are cases where the ratio, my lords, has gone up to 1:215. I will be requesting my colleague, my lords, to give your lordships the table. We have compiled it. This is based on the web note. The web note is at page 55 of our rejoinder. 55 and 56 of our rejoinder. And just for example, for the EWS category, my lords find the number of candidates qualified, that is serial number 2, is 2774. What this web note, my lords, I do not know deliberately or otherwise, what it withholds is that the total number of posts, and that's our table, is 49. 49 into 50 is 2450. What they have done is 2774. So the ratio there goes up to 1:57. And In another category, that is BCD, I'm just giving your lordships an illustration. BCD, the figure is mentioned, my lords, at 6324. What this web note of the Telangana Public Service Commission does not say is that the total number of posts were 22. 22 at 1:50 is 1100. They have, my lords, called 6324. The ratio jumps to 1:290. So this, my lords, this material demonstrates the arbitrariness in the process. That process I can only, my lords, challenge before your lordships if I have participated. So the ground raised by my friends on estoppel also does not lie.
Yes.
And lastly, my lords, this exercise that has been done violates GOMS 55 and does not even meet the standards of Baloji Badawat. The sheet anchor of my learned friend's case, my lords, if I have been instructed properly, was that Badawat's case justified GOMS 29. Badawat, your lordships have seen, and I will, my lords, not go back to that, except to say that Badawat, my lords, was in force when GOMS 55 was issued. Badawat does not lay down any principle, my lords, which can be held to override the entire catena of case law from Saurav Yadav to Dipender Yadav to Shobana, all of which have clearly said that separate merit lists have to be made and the allocation takes place, my lords, at the final stage, which gives a right to the BC candidates to have a chance to be absorbed basis on their merit in the general category if they have done well enough. Any other process would violate their right, because then it opens up far more indefinite candidates, my lords, to enter the fray. Secondly, what the web note shows is that even Badawat has not been adhered. In the GOMS, they have referred to Badawat, my lords, to create a justification. But the manner in which the process has been worked is not as per Badawat. All that Badawat said, as your lordships remember, is that watertight silos or compartments should not be allowed. Because if it is watertight, then there can be no, my lords, migration. That's all. So therefore, my lords, the reliance upon Badawat also is really a smoke screen to try and, my lords, distract from the real issue, which is that the PSC was directed by this Honorable Court, my lords, to reconduct. At that stage, certain vested rights were created. They could not have changed the rules or the eligibility, or for that matter, my lords, conducted a fresh round of examination at all. That conduct is contumacious.
That's all, Mr. Sondra.
That's, lords, I think that would suffice. Everything else I will give your lordships in a short written note. I'm so deeply obliged.
Yes. If anybody else wants to add on there.
My lords, I'm representing J. Sudhir, my lords. Senior is on the way, my lords. Kindly take it up at 2:15, my lords.
Anybody else wants to add on behalf of the petitioner? The other day, some person, petitioner in person, was also present. Yes, you can add.
May I express my gratitude, my lords, for a very patient hearing.
Thank you, Mr. Sodhi.
Grateful.
WP number, please tell your WP number.
32978.
WP
32978.
978
Yes, sir.
of 24.
Yes, sir.
May we know your name?
Suripalli Srinivas.
Mr. Srinivas, please don't. Don't repeat. No? You must have heard what has been argued for last few days.
Yes, sir.
Please don't repeat it. We are ready to hear you, but please don't repeat the same argument. If you want to add something, we are ready to hear you.
Sir.
Yes.
Sir, basically this GO is in the nature of a communal GO, in the sense that marginal communities are restricted to their lot in 1:50 ratio, as the data has already been sent to you, sir. SC category, it is 1:52. whereas ST, it is 1:53. Whereas for BCB, it is 204, and BCD, it is 287. So the proportionality justice has been highly skewed in favor of one and in disfavor of some others. This has been specifically mentioned by the then commission in their counter. So they said some of the communities will be overrepresented while others will be either low represented